Yeah, my name is Jeff Clayton. I'm the executive director of the American Bail Coalition. I've been working on bail and bail reform issues, meaning how people get out of jail when they're arrested, pending trial for a very long time. Worked as an attorney, practicing attorney for many years, federal civil rights cases and others. Now what I do is I work for a trade association of insurance companies called the American Bail Coalition, who underwrite criminal bail bondsmen throughout the United States. And since I've taken over, really, the focus is to protect the state and constitutional right to bail, which includes the right to use a bail bondsman to get out of jail if you choose to do so.
And right now here in California, on Tuesday, the 13th, Senate Bill 262, which is a bail reform bill, will be discussed. What is your perspective on this bill?
Well, I think there's a couple problems with it. Really what it does is that it implements the zero bail policy that we saw during the pandemic that was used as an emergency measure by the Judicial Council. And so that would take that policy that was applied for a few months during the pandemic and make it permanent in California. And I think the other major problem with the legislation is it and forces bail agents to give refunds to persons who will show up to court or the prosecutor won't file charges. And so what happens is if refunds are given to people who are innocent versus who are guilty, the problem is the bail industry will collapse. And to the extent there is a bail industry, only the guilty will get out. So it flips the presumption of innocence on its head. So I think we're going to see a lot of people getting out of jail that judges wouldn't otherwise let out or would require a bail or some supervision of them under this bill. And I think short-term, possibly long-term, without bail agents to bail people out because of the high bonds in California, people will end up getting stuck in jail.
So, Jeff, can you help us understand what are the mandates of the Senate Bill 262 regarding bail for average offenses, and which offenses or felonies would then be assigned bail if most would be considered misdemeanor or then would not be assigned bail?
Well, there's no bail for all misdemeanor charges. That's clear. And there's a few exceptions for some like DUIs and higher level cases. I think there's some domestic violence in there, but primarily all DUIs. And then you've got, probably the best way to think about it is all nonviolent felonies are pretty much swept into the no bail rule. But there's another provision that requires affordable bail. And so what's going to happen is even persons on the charges where there's not zero bail still are going to get a lower bail because of this right to an affordable bail that they're putting in the statute. So you're going to see a lot of automatic releases on all misdemeanors and nonviolent felonies, and then you're going to see a lot more releases on violent felonies and top-level charges. You're going to get a lot of people who judges would otherwise detain in jail or require them to post bail to either stay in jail or to get out for free.
What ways would you encourage the public if they're interested in maintaining bail over criminal offenses?
Well, obviously, we're encouraging the public to contact their legislators via email, or there's a portal called Safer Communities you can find online where you can, direct mail from your email box to your legislator and tell them how you feel. And certainly, you can call them. You can visit our website, ambailcoalition.org, or in this day and age, legislators respond to tweets. So tweet your legislator and let them know how you feel about this legislation.
And as a bit of a lobbyist, Jeff, is that the best strategy for appealing to people in power, is to tweet them or somehow reach them in social media? What do you recommend?
Well, I think the oldest rule in politics, and should be the oldest rule in politics, is that people who are elected should respond to their constituents. So if you want, something to happen, you need to convince the constituents of, whether it's a good or bad policy, and then they can, then the legislator represents the interests of their constituents. And so, anytime you get into one of these issues, you have to explain to people why this is a problem. For example, we don't think the legislature has the power to set a bail. That's a judicial policy. So we need to tell people that it's unconstitutional. So, constituents talking directly to their legislators is the number one, in my mind, effective way for constituents to let their legislators know and for legislators to do a good job of representing their constituents' interests.
So you're saying that it would be unconstitutional for the California Senate to set bail?
Yeah, we don't think the legislature has the power to set a bail. In other words, that binds judges. The California Constitution is very specific on what judges have to consider: prior criminal history, likelihood of appearance, impact on the victim, which basically means the severity of the current charges, are sort of the factors. The legislature can't substitute its judgment for what is called the inherent power of the judicial branch of government, which means to hear a case on a case-by-case basis. And here the legislature is just saying, if the prosecutor charges you with this, you get out for free. And that's not going to fly, because even during the pandemic, the California Court of Appeals ruled that the Judicial Council couldn't bind judicial discretion during a pandemic. And so if there's no emergency, I don't see how the California legislature can permanently bind judges.
Well, thank you so much for sharing your perspective, Jeff. And just to recap back, given that you have quite a bit of experience with bail itself, can you give us a little bit more perspective on Senate Bill 262 and this overall conversation in our legislature? What is going on here? Why are people opposing the bail system, and why are other people trying to uphold it?
Sure. I mean, I think there's been a concern for the last 5 years that there's people who can't afford bail that get stuck in jail because of lack of money. And I think that's true to a certain extent in California. I think the bails in California are way too high as compared to the rest of the nation. That's been a problem. But the first issue has been the number one issue going. And I think the California Supreme Court dealt with that in the People v. Humphrey case that came out in March, that basically said we need to shift the burden a little more onto the prosecutors to prove the need to keep somebody in jail. And so we're not just going to say there's probable cause and there's a bail. We're going to come back a second time, and a judge is going to have to take a real look at it. And so, we've been to the no money bail system, which was the whole 2018 Senate Bill 10 Prop 25 issue that the voters rejected. And here we are again the next year, after the referendum, trying something else that I still think is probably not the same solution. Or it's not a good solution. I think the legislators' best play is to follow the lead of the California Supreme Court and try to get at this, not have people held in jail solely because they can't afford it. Yeah, the history of bail is that we're a friend of the friendless, as one commentator said. We help people who need to get out of jail, and we post a financial guarantee to make sure that they show up in court. And if they don't, we're financially liable for them. So we stand in their shoes, and the Supreme Court says we actually take defendants into our custody. And same, if you post bail for a friend, you take them into your custody, and you're guaranteeing that they show up for court. So it's an important role that we play, and without it, the pressure to detain people and not let them out pending trial would be much greater.
So do you think there's an implication there that without bail, more criminals would not be fully assessed for their crimes?
Well, I think without bail, and we've learned this in the federal system and other systems, is that the government will over-detain. If people's right to bail can't check government power, you'll see government power to detain people expand, and we don't want that. That's the antithesis of our constitutional tradition in this country, where, as the Supreme Court has said, liberty is the norm, and detention the carefully limited exception.
Well, thank you so much for lending your perspective on bail and the potential reform of California's bail. I'm sure a lot of our listeners have faced criminal charges at some time and perhaps faced bail, and I hope that they have gathered a lot from learning from you.
Thank you. Thanks for having me on.